Mapp v. Ohio, Supreme Court, 1961. Justice Clark delivered the opinion of the court. Appellate stands convicted of knowingly having in her possession and under her control certain lewd and lascivious books, pictures, and photographs in violation of Section 2905.34 of Ohio's Revised Code. As officially stated in the syllabus to its opinion, the Supreme Court of Ohio found that her conviction was valid, though based primarily upon the introduction in evidence of lewd and lascivious books and pictures unlawfully seized during an unlawful search of defendant's home. On May 23, 1957, 3 Cleveland police officers arrived at appellant's residence in that city pursuant to information that a person was hiding out in the home who was wanted for questioning in connection with a recent bombing, and that there was a large amount of police paraphernalia being hidden in the home. Miss Mapp and her daughter, by a former marriage, lived on the top floor of the 2-family dwelling. Upon their arrival at the house, the officers knocked on the door and demanded entrance, but appellant, after telephoning her attorney, refused to admit them without a search warrant. They advised their headquarters of the situation and undertook a surveillance of the house. The officers again sought entrance some 3 hours later, when 4 or more additional officers arrived on the scene. When Miss Mapp did not come to the door immediately, at least one of the several doors to the house was forcibly opened, and the policemen gained admittance. Meanwhile, Miss Mapp's attorney arrived, but the officers, having secured their own entry and continuing in their defiance of the law, would permit him neither to see Miss Mapp nor enter the house. It appears that Miss Mapp was halfway down the stairs from the upper floor to the front door when the officers, in this high-handed manner, broke into the hall. She demanded to see the search warrant. A paper, claimed to be a warrant, was held up by one of the officers. She grabbed the warrant and placed it in her bosom. A struggle ensued in which the officers recovered the piece of paper, and as a result of which they handcuffed appellant because she had been belligerent in resisting their official rescue of the warrant from her person. Running roughshod over appellant, a policeman grabbed her, twisted her hand, and she yelled and pleaded with him because it was hurting. Appellant, in handcuffs, was then forcibly taken upstairs to her bedroom, where the officers searched a dresser, a chest of drawers, a closet, and some suitcases. They also looked into a photo album and through personal papers belonging to the appellant. The search spread to the rest of the second floor, including the child's bedroom, the living room, the kitchen, and a dinette. The basement of the building and a trunk found therein were also searched. The obscene materials for a session of which she was ultimately convicted were discovered in the course of that widespread search. At the trial, no search warrant was produced by the prosecution, nor was the failure to produce one explained or accounted for. At best, there is, in the record, considerable doubt as to whether there ever was any warrant for the search of defendant's home. The state says that even if the search were being made without authority or otherwise unreasonably, it is not prevented from using the unconstitutionally seized evidence at trial, citing Wolf v. People of the State of Colorado in 1949. But there are cases of this court, some passing references to the Weeks rule as being one of evidence, but the plain and unequivocal language of Weeks and its later paraphrase in Wolf to the effect that the Weeks rule is of constitutional origins remains entirely undisturbed. Since the Fourth Amendment's right of privacy has been declared enforceable against the states through the Due Process Clause of the 14th, it is enforceable against them by the same sanction of exclusion as is used against the federal government. Were it otherwise, then just as without the Weeks rule, the assurance against unreasonable federal searches and seizures would be a form of words, valueless and undeserving of mention, in a perpetual charter of inestimable human liberties, so too, without that rule, the freedom from state invasions of privacy would be so ephemeral and so neatly severed from its conceptual nexus with the freedom from all brutish means of coercing evidence as not to merit this court's high regard as a freedom implicit in the concept of ordered liberty. At the time that the court held in Wolf that the amendment was applicable to the states through the Due Process Clause, the cases of this court had steadfastly held that as to federal officers, the Fourth Amendment included the exclusion of evidence seized in violation of its provisions. Even Wolf stoutly adhered to that proposition. The right to privacy, when conceded operatively enforceable against the states, was not susceptible of destruction by a vulsion of the sanction upon which its protection and enjoyment had always been deemed dependent. Therefore, in extending the substantive protections of due process to all constitutionally unreasonable searches, state or federal, it was logically and constitutionally necessary that the exclusion doctrine, an essential part of the right to privacy, be also insisted upon as an essential ingredient of the right newly recognized by the Wolf case. In short, the admission of the new constitutional right by Wolf could not consistently tolerate denial of its most important constitutional privilege, namely, the exclusion of the evidence which an accused had been forced to give by reason of the unlawful seizure. To hold otherwise is to grant the right, but in reality to withhold its privilege and enjoyment. Only last year, the court itself recognized that the purpose of the exclusionary rule is to deter, to compel respect for the constitutional guarantee in the only effectively available way, by removing the incentive to disregard it. Indeed, we are aware of no restraint similar to that rejected today, conditioning the enforcement of any other basic constitutional right. The right to privacy, no less important than any other right carefully and particularly reserved to the people, would stand in marked contrast to all other rights declared as basic to free society. This court has not hesitated to enforce as strictly against the states as it does against the federal government the rights of free speech and of a free press, the right to notice and to a fair public trial, including, as it does, the right not to be convicted by use of a coerced confession, however logically relevant it be, and without regard to its reliability. And nothing could be more certain than that when a coerced confession is involved, the relevant rules of evidence are overridden without regard to the incidence of such conduct by the police, slight or frequent. Why should not the same rule apply to what is tantamount to coerced testimony by way of unconstitutional seizure of goods, papers, effect, documents, etc.? We find that, as to the federal government, the Fourth and Fifth Amendments, and, as to the states, the freedom from unconscionable invasions of privacy and the freedom from convictions based upon coerced confessions do enjoy an intimate relation to their perpetuation of principles of humanity and civil liberty secured only after years of struggle. They express supplementing phases of the same constitutional purpose to maintain inviolate large areas of personal privacy. The philosophy of each amendment and of each freedom is complementary to, although not dependent upon, that of the other in its sphere of influence. The very least that together they assure in either sphere is that no man is to be convicted on unconstitutional evidence. Moreover, holding that the exclusionary rule is an essential part of both the Fourth and 14th Amendments is not only the logical dictate of prior cases, but it also makes very good sense. There is no war between the Constitution and common sense. Presently, a federal prosecutor may make no use of evidence illegally seized, but a state's attorney across the street may, although he supposedly is operating under the enforceable prohibitions of the same amendment. Thus, the state, by admitting evidence unlawfully seized, serves to encourage disobedience to the federal Constitution, which it is bound to uphold. In non-exclusionary states, federal officers, being human, were by it invited to, and did, as our cases indicate, step across the street to the state's attorney with their unconstitutionally seized evidence. Prosecution on the basis of that evidence was then had in a state court in utter disregard of the enforceable Fourth Amendment. If the fruits of an unconstitutional search have been inadmissible in both state and federal courts, this inducement to evasion would have been sooner eliminated. There would be no need to reconcile such cases as Ray and Schnettler, each pointing up the hazardous uncertainties of our heretofore ambivalent approach. Federal-state cooperation in the solution of crime under constitutional standards will be promoted, if only by recognition of their now mutual obligation to respect the same fundamental criteria in their approaches. However much in particular case insistence upon such rules may appear as a technicality that inures to the benefit of a guilty person, the history of the criminal law proves that tolerance of shortcut methods in law enforcement impairs its enduring effectiveness. Denying shortcuts to only one of two cooperating law enforcement agencies tends naturally to breed legitimate suspicion of working arrangements whose results are equally tainted. There are those who say, as did Justice, then Judge, Cardozo, that under our constitutional exclusionary doctrine, the criminal is to go free because the constable has blundered. In some cases, this will undoubtedly be the result, but there is another consideration, the imperative of judicial integrity. The criminal goes free if he must, but it is the law that sets him free. Nothing can destroy a government more quickly than its failure to observe its own laws, or worse, its disregard of the character of its own existence. As Mr. Justice Brandeis, dissenting, said in Olmsted v. United States in 1928, our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. If the government becomes a lawbreaker, it breeds contempt for law. It invites every man to become a law unto himself. It invites anarchy. Nor can it lightly be assumed that, as a practical matter, adoption of the exclusionary rule fetters law enforcement. Only last year, this court expressly considered that contention and found that pragmatic evidence of the sort to the contrary was not wanting. The ignoble shortcut to conviction left open to the state tends to destroy the entire system of constitutional restraints on which the liberties of the people rest. Having once recognized that the right to privacy embodied in the Fourth Amendment is enforceable against the states, and that the right to be secure against rude invasions of privacy by state officers is, therefore, constitutional in origin, we can no longer permit that a right to remain an empty promise. Because it is enforceable in the same manner and to the like effect as other basic rights secured by the Due Process Clause, we can no longer permit it to be revocable at the whim of any police officer who, in the name of law enforcement itself, chooses to suspend its enjoyment. Our decision, founded on reason and truth, gives to the individual no more than that which the Constitution guarantees him, to the police officer no less than that to which honest law enforcement is entitled, and to the courts that judicial integrity so necessary in the true administration of justice.